Hi guys, Colleen here with the English Law Group. I am a licensed attorney in Kentucky and in Indiana. So any information I talk about today is going to be according to those states. As always, this is general information. Please seek legal advice for any situation that you have going on specifically. Today, I want to talk to you about what happens if you die without a will and you are married. So sometimes I will talk to people and they're married and they think that if they die without a will, everything by law would go to their spouse. That's not the case. You cannot disinherit a spouse, but it is very rare that there will be no relatives there that would stand in the place of the spouse taking 100%. In some instances that could happen, but you got to go through a lot of people to get there. So want to talk to you guys about a little bit of what that looks like. So when I talk about your estate, I am talking about those things that you own that are not in both of your names. So if you have a piece of real estate that you own prior to getting married and you never add your spouse to the deed, if you die, then your spouse is not going to get 100% interest in that house, even if they've been living there for 20 years. Doesn't matter what they've put into it. That's just not the way that it goes. So this is how it would be run down. So if you cannot, so first of all, just to let you know, luckily you cannot disinherit a spouse. So the state does not want your spouse to become a public ward and have to depend on them. So basically you cannot disinherit your spouse. Even if you don't leave them something, let's say you do have a will and you're like, absolutely not, it's not going to my spouse. Then they can, in Kentucky, they can get 1/2 of your estate, give or take. And there's a little bit of a nuance to that, but generally speaking, 1/2. That's called a dower interest in as a woman, as a wife. The husband's interest would be called your curtsy interest. In Indiana, that is a 1/3 share. And throughout all of the 50 states, there is something like this in place. So I don't know of any state where you can 100% disinherit your spouse. Now, if you have a prenuptial or postnuptial agreement that meets all of those requirements, that's a different story for another video and another day. But generally speaking, you cannot disinherit your spouse. So let's say that your spouse owned a piece of real estate before you got married and you never went and got your name put on title to the property. In that instance, this is how it would go. Why is this not going? Okay. So if you die without a will, everything would go to your children. And if that means that you were this person's second marriage, or maybe they just have children from a previous relationship, then those children get part of the house too. If they're both of your children, great. But in order to do anything with that property, you would have to be appointed the guardian, legal guardian through probate court, and you would have to get the court's permission, file annual reports, all kinds of red tape, way more red tape than just getting a will done. If you do not have any children, then it would go to your spouse's parents. So unless you want to own a piece of property with your in-laws, you better get that will done, or you better get added to the deed. If your in-laws have already died, then it would go to your brother and sister-in-laws. It would go to your spouse's siblings. So, and on down the line. So if you are okay with owning a piece of property with all those people, leave it as it is. Most people are not. So there is an easy way to fix this. All you have to do is get a will. Have your spouse sign a will. Typically, people would want to leave things to their spouse. In some instances, if they do have children from previous marriages or previous relationships, and they want to make sure that they get something, in a will, they would have to at least leave 1/2 to their spouse. If they don't leave it, the spouse could get it anyway. The only way to avoid that would be to put something in a trust, or to even do, and then it gets kind of tricky with marital assets going in there, or to do a pre or postnuptial agreement, which have very specific disclosure issues, duress issues, all kinds of stuff like that. So the very short solution to this is make sure that you are on title to property with your spouse. If you do not want to do that, at least get a will in place. Do not pull it off of Google. I love Google. I search up stuff all the time. You may have found me through Google, but it is not an appropriate place to create legal documents. Spring for a little bit of money, get your attorney to draft it, give us a call. We would be happy to walk that through you through that. And there's a lot of things that you may not have thought about and ways that you can preserve assets and keep your kids taken care of if that's the case as well, by doing a little work ahead of time that would reduce a lot of red tape and sticky situations later on down the road. If you like this type of information, please like and subscribe to our YouTube station, and we hope to see you soon.